Hi, everybody. My name is Renee Black. I'm very happy to have you here today. Thank you so much for being part of session 3 for the Design for Integrity webinar series. I am so pleased today to be joined by my friend Peter Chapman, who is based in DC, and by Maddy Batt, who is part of Tech Justice Law. Peter's with the Knight-Georgetown Institute. And we are very pleased to be having a talk with you today about the recent rulings in New Mexico and what that means for tech policy. We're going to be hearing a little bit about what was revealed during some of those cases, what some of the implications of those might be on tech policy, what was learned, and what we can think about going forward as we move into different stages. Here in Canada, we are in the process of developing a new online harms bill. So it's a very timely moment for this conversation. Um, Before we jump into our conversation, I would like to acknowledge that I am here in Halifax, Nova Scotia today, located in Mi'kma'ki, the ancestral and unceded territories of the Mi'kmaq people. These are sovereign nations that hold inherent rights as the original peoples of this land, and we can each carry collective obligations under the peace and friendship treaties. We recognize that at this moment in time where Canada is facing a range of forces from outside of our control and that are making digital sovereignty an urgent priority for Canadians, that it is also important to make sure that we are looking for strategies to uphold and uplift digital sovereignty for Indigenous peoples in Canada as an integral part of our commitment to reconciliation. A few other things I want to mention before we get started. This series is made possible by the Council on Technology and Social Cohesion, and I'm so happy to have Peter, who is a fellow member of the Council on Technology and Social Cohesion, here with us today. Yeah, I think that's where we're going to get started. Maddy, Peter, thank you so much for being here with us. I'd love you to just take a moment to introduce yourself. Peter, you want to get us started?
Sure. Yeah, thanks, Renee. Great to see some familiar names on the call. My name's Peter Chapman. I'm the Associate Director of the Knight-Georgetown Institute in Washington, D.C. KGI is focused on connecting independent research with technology, policy, and design. And in the US context, but also around the world, courts are playing a considerable role in tech policy. So we have been working on issues related to litigation here in the United States and looking at what learnings are coming out of those processes, as well as how independent research and empirical evidence can contribute to those processes. Really excited for you for convening this conversation, Renee.
Thanks. Maddy, please tell us a little bit about you.
Yeah, I'm Maddy, she, her pronouns. I'm a legal fellow at Tech Justice Law. We are a pioneering impact litigation and advocacy organization that works to defend communities harmed by big tech. We work across both sort of consumer rights and human rights issues. We represent several different plaintiffs who have been harmed by AI chatbots in particular. And yeah, really excited to be having this conversation today.
Thanks so much. And I do want to mention that we are going to be using Slido throughout today's conversation. So if you did want to ask some questions during the call, we will take those questions towards the end. So the issue that we really wanted to talk about today is this March, Meta and Google were found liable in two landmark rulings for failing to safeguard children from sexual exploitation and from misleading the public about alleged harms that were happening in apps like Facebook and Instagram. And just last week, Meta joined YouTube, Snap, and TikTok in settling with a school district in Kentucky over claims related to the cost of responding to mental health impacts as well. The case in New Mexico was in addition to a private plaintiff in California that also found that Meta intentionally built addictive social media platforms that harmed the mental health of users and deceived users regarding safety features. Now, the New Mexico Attorney General is seeking to declare Meta a public nuisance and arguing for injunctive relief. And so, what we want to do is get into a little bit about what we learned in these trials and try to get a bit of a sense for what it can tell us about what policy might look like. So maybe, Peter, could you just start out by giving us a bit of a recap around what we learned from these cases and what kind of kicked them off and how maybe they are different from other cases that have come before them?
Sure. Yeah, thanks, Renee. I think these two cases, one in LA and one in New Mexico, where juries returned verdicts against Meta as well as Meta and Google slash YouTube, sort of elevated these cases to sort of front page news. But maybe taking a step back and sort of putting them in context, those two cases are part of thousands of claims that are navigating through US courts. And historically, cases have focused on a range of claims related to social media, including sort of more content-oriented claims, like whether in the case of Twitter or YouTube, those platforms provided sort of material support to terrorism, which went all the way up to the US Supreme Court. What the cases in LA and New Mexico sort of allege or assert are claims that are more specifically focused on harms to minors that arise from the design of social media platforms. And as individuals, parents, family members, minors, school districts, state attorneys general, Native American tribes, as different groups have started to bring claims or began to bring claims related to the design of social media platforms and some of the harms that that design contributes to, two sort of civil procedure processes occurred. One around state claims in California. So the case in Los Angeles with Kaylee, known by her initials as KGM, as the first plaintiff, is the first of about 1,500 cases that were consolidated in a joint coordinated civil procedure, which is a U.S. state level process where the claims are sort of clustered and there's common sort of discovery and engagement with the attorneys. And there is a companion or sort of parallel process through what's called a multi-district litigation in Oakland, California, where a number of attorneys general claims, individual claims, and school board claims are also consolidated. And this is a bit of a long introduction into these cases, but I think it's important because they're representative of many hundreds of similar types of cases. And there's a sort of mix of private plaintiffs who sort of allege that they or their children have been harmed by social media products. And then there are public institutions like school boards and attorneys general. They broadly are, alleging harms to minors, impacts around sleep deprivation, depression, self-harm, sort of exposure to child exploitative content, and other sort of physical and mental health impacts. But with the private plaintiffs, they're sort of pursuing a products liability type set of claims. So things like, design defects, this product was designed in a faulty way, negligence, a sort of common law that I'm sure is relevant in Canada as well as sort of deceptiveness of their business practices. The public institutions bring similar types of claims, but also layer on broader sort of consumer protection and unfair trade practices type claims. And what occurred in New Mexico in the case of the attorneys general case and in Los Angeles resulted in verdicts coming back against these companies where juries, American citizens, found that the companies were played a substantial role in the harm to an individual plaintiff or the harm to New Mexican consumers. And what's interesting is that both the LA case was selected as a sort of, it's called a trial pool case or a bellwether case, that is because it was broadly representative of the hundreds of cases coming behind. Those cases will also see their day in court so long as they're not settled. And the next case in LA will start in July, and attorneys general in Northern California will see new cases trials begin in August. So the next half year in the United States is likely to see quite a significant amount of either trials and/or negotiated settlements with these companies.
You're alluding to something I want to draw out as a bit of a frame here, so that we have the content layer of policy. A lot of policy, including in Canada, has focused on the content layer of what do we do when bad content is or content that is harmful has been put up online. This is starting to shift more towards the design governance orientation, and I think we also kind of see that there's an interplay also with monetization, the way that these tools are used for monetization. Maybe can you help us to draw out a little bit about what was found, what was the evidence that came out and emerged during these cases? Matt, do you want to kick us off?
Yeah, for sure. So I think there were two sort of key categories of significant findings from the internal documents that were received from these companies. One is sort of the degree to which they were intentionally optimizing for time spent online. And that's something that kind of makes sense that we saw because we know that the way that these companies make money is from targeted advertising. And so as a result of that, the more time that people spend online, both looking at more ads and also providing more data to the companies so that they can target ads more effectively, the more money they make. And so what we saw in the internal documents was a very intentional engineering of products to keep people online as long as possible through these addictive features. And so that's sort of one category that was significant was the intentionality of the engineering of these addictive products. And then the other side was documents really showing the awareness of the mental health harms that that kind of engineering would cause downstream. And that was both in sort of these internal studies that were not released, in some cases were kind of shut down, as well as specific kind of communications between employees that folks might have seen widely reported. There was one kind of communication from a Meta employee who said that people at Meta were pushers because social media was a drug, really just demonstrating a degree of understanding of the kind of harms that their products were causing that they weren't sort of revealing or warning people about publicly, that I think really is emblematic of why people are calling this a big tobacco moment.
Great, thanks. Peter, do you want to add on to that as well? Because I think you've also talked about some of the safety features that have been created, but also the limits that they have been designed with. I mean, can you talk a little bit about that?
Yeah, I think Maddie really summarized it really well. And I think particularly because a number of these cases are rooted in this notion that the platforms misrepresented their safety, specifically for minors, as well as failed to warn consumers, minors, and parents about sort of foreseeable risks on the platform. And in addition to sort of that engagement optimization, the sort of sufficiency of the safety tools of these platforms has been central to the litigation, which is interesting from a comparative standpoint because that's also central to the sort of unfolding of regulation in other jurisdictions, notably the Digital Services Act, Online Safety Act in the UK, and Digital Services Act in the EU. And so a few months ago, we at KGI put out a report called Measuring Risk, which really sought to sort of read two bodies of evidence in parallel. One was what are platforms saying under the Digital Services Act in relation to risks when it comes to mental health and sort of protection of minors? And then what are we learning in the litigation context about the specific representations or the specific communications they're making in the European market? And we looked preliminarily at Meta and TikTok and found some interesting distinctions. I think the risk assessments in Europe focus significantly. Well, first of all, they focus on a similar set of risks than the litigation in the United States. So there are concerns around the protection of minors, around mental health and well-being. Both Meta and TikTok, describe how they assess those risks and understand those risks. And then they each list a sort of inventory of policies and mitigation measures they take on the platform. And many of these are global approaches, not just limited to the European market, though the Digital Services Act, of course, is. And so they describe the tools and policies they have to manage these risks. And in the US context, we see much more granular data around those specific risks and mitigation effectiveness. So, for example, TikTok 2 years ago in Europe described the risk of sort of extended use or problematic use for minors, particularly. So people who spend a lot of time on the platform and then in aggregate suffer harms as a result of those that time spent. And they don't really provide any details about how much time people are spending or the types of tools that TikTok offers to manage those risks. So they point to screen time management tools as a central mitigation. In the US context, however, the experts retained in the US cases were able to look at specific patterns of use. And so in the US context, the average time spent by minors, sort of by percentile, suggests that the 90th percentile of 13 to 17-year-olds on TikTok are spending about 4 hours a day on TikTok. The top 1% or 99th percentile are spending more than 6 hours on TikTok. So that sort of denominator is really important to understand when you start thinking, when you talk about mitigating extended use. We then see through litigation disclosure of a detailed conversation that TikTok had about rolling out screen time management tools for users, including the fact that leadership approved the rollout of these tools on the condition that they would not reduce time spent on the platform more than 5%. So when you do the math then around if the 99th percentile is using it for more than 6 hours, that's a 20-minute reduction. So from 6+ hours to 5 hours and 45 minutes is like the signature mitigation tool to manage extended use. And I think really critically, we see the conversation play out internally as well about the assessment of monetization impacts associated with this reduction. And so you have people commenting in docs that have been disclosed in Discovery saying, we really need to talk to, the sort of core revenue team about this intervention, underscoring what Maddy points out about just how central these determinations are. And I think that's not surprising to any of us, given how these platforms make money, but it is directly connected to these questions around sort of potential deception and failure to warn in terms of these US cases. And so for us, the takeaway we have from that sort of example, and there are other examples in this report that you can go look at, is it just underscores how much data and evidence the platforms are relying on to make decisions about safety, about sort of how product features are rolled out, what features are default, which are not. And generally, we don't see that data and evidence in platforms' public communications around safety in the US market or in these risk assessments in Europe about how they're effectively mitigating risks in that market.
Can you talk a little bit more about the deceptive practices side? So, I mean, there's a part of these cases is that they deceived customers around the safety features. So, can you talk a little bit about what deception arguments were made in that context?
Yeah, I can jump in on that. So this is specifically relevant for the New Mexico verdict, but there are also plenty of other cases still making their way through the courts that are raising these kind of claims. And in New Mexico specifically, the claim was brought under state consumer protection law, so New Mexico law, and it focused on the disparity between the way that Meta executives talked about the platform safety for children, including putting out kind of very specific statistics about the rates of harm that users were experiencing, that when you dug into them a little more were highly misleading, didn't cover kind of the full range of harms that people experienced, only covered harms that were reported, while Meta knew that it was making the reporting process quite difficult for the amount of sort of harm that people were facing. So kind of looking at these representations about a platform that was highly safe for children, while also having information about the harms that children were experiencing on Meta's platforms, both social media addiction fueled by the intentional design choices made by Meta, as well as the child sexual exploitation that existed on the platforms, which I think critically New Mexico showed is not just a matter of kind of malicious users coming onto the platform, but was really facilitated by specific features that exist on Meta platforms, from kind of algorithms that recommend predators to children's accounts, or kind of suggested search terms and suggested accounts that will kind of suggest alternatives to blocked search terms associated with child sexual abuse material, for example. And so that's one example of kind of a case that really gets at harmful design features by looking at the disparity between public representations from the company and the design choices that it is actually making. And I'll add that this shows up across not just the kind of youth harms space, but in other kinds of harms that people experience on social media platforms too. So for example, Tech Justice Law recently filed a lawsuit focused on scam ads on Meta's platforms, which accounts for a really kind of astonishing percentage of Meta's revenue. And it's a very similar case to what Peter was talking about, where they kind of refuse to implement safety measures if they would cost too much of Meta's revenue, which in a kind of environment where it's making so much money for scam ads, that is a huge impediment to any meaningful sort of safety measures being implemented.
Mm-hmm. Yeah, I mean, I think just generally speaking, the issue of trying to place burden on the rhetoric around malicious actors doing malicious things really is intended to try to distract from, first of all, place the blame and burden of individuals having to figure out all these different types of harms that are happening, whether it be mental health or whether it be scams or whether it be disinformation onto the user. And so I guess there is this intersection between the monetization and the design side. So can we maybe talk a little bit more about how those two intersect as we're going through this?
Sure. Maybe I can give one more example from our measuring risk report, just around this time looking at sort of Meta, where Meta and Instagram, describe in the U.S. market as well as in Europe the range of tools that they have to prevent child sexual exploitation on the platform. I mean, like, this is a sort of area where there's not really a constituency for this type of engagement on the platform. And they list all of these sort of tools, but they don't talk about the design of the platform in potentially enabling connections to take place. And what we see in the US context is that, Meta describes its risk of connecting bad actors to minors, and obviously describes its policies of saying that sort of that type of those connections shouldn't be created, and their specialized tooling to sort of identify these suspicious actors that may be targeting minors. But then again, to Maddie's point, like, we see an internal series of studies on Facebook and on Instagram that talk about the specific role that two product features, the Facebook's People You May Know feature that has sort of like the recommended accounts when you're on Facebook, or Instagram's accounts you may follow recommendations that are sort of being proactively surfaced to users. And they describe in some detail about how this specific feature was recommending folks who were suspected to be adult groomers to minors and vice versa. And in the context of Facebook, there was actually a study that said that the actual recommendations through the People You May Know tool was responsible for 80% of all policy violating content the content that violated Meta's policies around minor and adult connection. And 80% of it was downstream of the platform's own account recommendation. So they decide, they describe how it's prohibited. They describe the safety teams that are doing this proactive detection and tooling and the content moderation and the trust and safety teams. But then, there's a product study that shows that actually like the platform itself is making these recommendations and in sort of triggering or downstream from 80% or upstream from 80% of this policy violating content. And so I think it's another example of where a platform sort of sees this, but then discusses about the friending losses and the engagement declines associated with changing the feature. And these are the things that the sort of litigators in terms of the misrepresentation claims are really seizing on. They're saying you're doing everything you can to prevent this, but you're also aware of a feature that's creating connections between minors and adult groomers, and you're discussing the losses in friending and engagement that would come from changing to a more safe default setting for minors. And I think that is the type of transparency that the U.S. litigation is sort of driving. That's pretty different from the transparency that we see in Europe.
One additional thing I just want to add about the connection between monetization and design as well is I think it really helps underscore part of the significance of these verdicts, and especially the LA verdict, where there was a finding that the platforms were negligently designed, because I think it really is in some ways a pretty existential finding, because the same features that were contributing to the jury's conclusion that this platform was negligently designed, was designed in a way that causes social media addiction and mental health harms, are the features that the platforms use to make money. So there is a really clear connection here between the platform's monetization and the design features that are making these platforms unsafe that I see as a significant part of why these cases are so important.
Yeah, I know there's been a big focus in Canada. There's been discussion around perhaps having an age gate for social media. Similarly in EU, I know that there was a big discussion, lots of conversations last week at CPDB around this, and Australia now has had a social media ban for a year. I mean, I guess one of the questions that I wonder about is whether or not that is a good policy to have. It strikes me that because this advertising component is so crucial and fundamental, doing verification to make sure that people are doing financial transactions in a social media environment where this monetization is being used potentially to harm people. If we were going to do verification, I would prioritize focusing on the people who are doing these financial transactions, who are incentivizing some of these cases. So like putting out ads that are scams, but also maybe that, it sounds like a lot of the sponsored content and other recommended content is coming up in here. Does that resonate to you, or what are your thoughts on that?
Yeah, I think it definitely resonates. I feel like for me, what I sort of take from the cases is the importance of really upstream policy decisions that will shape kind of the incentives that these platforms have to keep people online in the ways that are harming them. So I see it as, the algorithms that are optimized for engagement as something that really needs to be addressed upstream of sort of specific individual user experiences. Data collection and use, I also think, is sort of a big piece from a policy perspective that we need to be looking at, because of the degree to which the targeted advertising and kind of targeted content that is making these platforms money is only possible with the vast amount of data collection that they're doing, and then the use of that data to kind of target people with advertising and content. And so I think these are part of the aspects of these platforms that really create the incentives and ultimately produce the addictive design problems that were at issue in both of these lawsuits. And so for me, it really underscores the need to be looking at kind of at the level of platform design and designing for safety is, I would say, kind of where I see as the ultimate priority.
Okay, great. Peter, I mean, I know that the data collection is a big part of what's coming out of the remedies. So maybe can you talk to us a little bit about the remedies process that you're working on, the kind of proposals that are coming up, and how you hope that they start to make a change within these platforms?
Sure. And to answer that, I think it makes sense to again sort of take a step back and look at the different types of cases.
Mm,
So the LA case with an individual plaintiff resulted in a verdict that caused Meta and YouTube to pay $6 million. They, of course, have appealed that verdict. And it should also be notable, or it should be pointed out that on the eve of that trial, Snap and TikTok settled with the plaintiff. And perhaps coincidentally, Snap rolled out new parental control features or announced new parental control features 24 or 48 hours after that settlement. I think with TJL and the litigation against Character AI, you also see Character AI announcing all sorts of steps around age verification and more appropriate experiences following following the filing of that case and sort of failing on their motion to dismiss. So I think private litigants can also sort of catalyze real design change. But in the attorneys general cases in particular, there are specific claims that are focused on injunctive relief. And so New Mexico had an initial trial where a jury found Meta liable and ordered a $350 million payment, which is sort of determined through New Mexico statute. A second phase, which ended on Friday, I believe, and I think the sort of written closing arguments from Meta and the New Mexico Attorney General are due in mid-June. It was rooted in a public nuisance claim, which sort of refers to conduct that interferes with the right of New Mexican citizens broadly. And this kind of type of claim was the sort of the theory for the landmark 1998 Tobacco Master Settlement Agreement and has been used in litigation in really diverse areas, from everything from sort of gun sales to water pollution and sort of environmental contamination. And so, in the context of New Mexico's public nuisance claims, the Attorney General has laid out about 50 design changes that they would like the platform Meta to undertake, and those range from steps around age verification, designs related to online child sexual exploitation, extended use designs like infinite scroll and autoplay, as well as appointing a court sort of appointed monitor to actually confirm that the safety features that Meta sort of agrees to through this or is ordered to comply with through this case are implemented in ways that actually reduce harm over time. And we at KGI, together with Maddy and her colleagues at Tech Justice Law, as well as the team at the USC Neely Center, have been focused on remedies and trying to sort of leverage learning from remedies and other kind of systemic types of litigation, whether that's public health, tobacco, opioids, e-cigarettes, civil rights, or technology litigation. And last or 2 weeks ago, we put out a framework called Designing Technology Remedies, which tries to sort of synthesize a lot of these experiences and articulate what effective remedies in the social media and AI chatbot space could look like. And broadly, we cluster those around sort of three categories of remedies. One is harm prevention, which really seek to intervene to actually prevent the occurrence of future harm by changing how companies design, develop, or deploy products or features. There's another bucket around sort of harm mitigation remedies, which give users more control over their experiences on digital platforms. I think another sort of insight from the US litigation is just how important default features matter. So where platforms make safety features default, 70–80% of users keep those defaults. Where they make them opt in, maybe 1.5%, 2% of users opt into the safe experiences or safer experiences. So when we think about mitigation, accounting for those defaults and sort of enabling users to have real autonomy in how they control their safety. And then lastly, the sort of governance remedies that align with ensuring that what's agreed in settlement or in a decision is actually operationalized, but also putting in place processes to prevent harmful decisions being made in the first place. And these include things like sort of compliance structure, but also transparency mechanisms and independent sort of researcher access to ensure that the harms alleged in sort of litigation are reduced over time.
Yeah, I really want to go into that independent researcher access because, as you know, we discussed before, there's been this mechanism in the EU's Digital Services Act to provide access to data for researchers, and so far, of none of the approvals have occurred. All of the requests that have been denied, and so it's been a slow process to move that forward. And so there's in some ways there's been more data made available because of these legal cases. So for a country like Canada, or any other country really that's trying to figure out what their approach is to both getting access to data and to evidence, how do you think about what kind of disclosure obligations, and what kind of transparency arrangements might be useful for thinking about how to move forward with a policy?
Yeah, it's a really good question. I mean, I think I was in Europe last week and asked by several Europeans quite directly, like, is the US litigation approach just better from a transparency perspective? I think we're far too early into the process to really know. I think it's indisputable that we have seen internal company studies and documents come out through US litigation that we have not seen emerge through other transparency mechanisms. But obviously, Digital Services Act sort of attempts to create a much more structured form of data access. So under the Digital Services Act, there's access to publicly available platform data as well as private data. So the sort of applications that have so far been denied are really around that private data. Researchers can analyze data that is publicly available in the interface to sort of understand the nature of online conversations and get at some of these sort of design considerations. There are also all sorts of other elements of transparency in the Digital Services Acts related to ads and content moderation decisions and other pieces. I think not knowing the sort of specifics of the current conversation in Canada around platform transparency, I do think there is an opportunity really to learn, though, from these different approaches at this current moment. And ultimately, transparency mechanisms, in my view, need to be rooted to questions of like, who are you really targeting? Like, what data and information is relevant for which audiences? And I think there has been a tendency to sort of ask broadly for more transparency without always thinking specifically about how it can be actionably like, acted upon. So I think in the context of Canada, those would be my recommendations.
Mhm. Okay, great. A reminder that we're going to be going to some questions. So if you have not already had a chance to put your questions in Slido, please do. We'll get there in a couple of minutes. So I guess there's quite a few cases on the horizon. Is there anything that is different that you're expecting to come out that we might learn from these other cases? Are they building on what we've already heard in the two cases that we've just seen? Are there new dimensions, and what do you hope might happen with those cases?
Yeah, I think the answer is both, that they're kind of building and that there are some differences. Um, so I'll just mention first and foremost, not all of the legal theories that are currently making their way through the courts have yet been tried or yet reached a verdict. So, for example, the successful New Mexico AG decision that we've already had was focused on consumer protection law. Now the issue of public nuisance is being litigated, and we don't yet have a judicial decision on that. So I'm really interested to see how that case will come out, because there are several other public nuisance cases making their way through the courts, and that could be a really significant decision. There was also, interestingly, so Peter talked about the difference between kind of the state level coordinated proceeding, where we saw the trial in LA, and then cases in the sort of federal coordinated proceeding. They were scheduled to have a bellwether trial for one of the school districts that has brought a case, Breathe It, a school district in Kentucky. And all of the social media companies, even Meta, which initially was a holdout, decided to settle that case with the Breathe It school district. And, you know, even though it is sort of making similar types of claims to what was brought forward in LA, there are sort of legal differences associated with school districts as a plaintiff bringing these types of arguments about the harm that they've faced into court. So I was interested to see that the companies had all chosen to settle that bellwether, even the ones that went forward with the LA case and then ultimately lost. And so I also have my eye on future school district cases. And then across the board, I would say, as Peter kind of alluded to earlier, these two successes that we saw were kind of associated with a willingness to recognize that litigating platform design features is distinct from litigating platform content and harms caused by content. In the past, the reason that tech companies have had such a winning record in court generally relates to their reliance on these particular defenses. Section 230, which is a statute in the US that generally speaking prevents platforms from being held liable as publishers for third-party content. And then the First Amendment, of course, they've been leveraging also to protect against liability associated with content. And I would say these decisions represented a much more common sense approach to recognizing that there is harm that comes from design that you can separate out from the harms that people experience related to content online. And they're kind of very significant for showing that accountability is possible. And as we continue to see cases go to trial, we'll continue to get a better picture of kind of whether, as I hope it will, the kind of judicial consensus really consolidates around this more common sense view around Section 230 and the First Amendment and accountability for design-based harms than we've sometimes been able to see in the past.
Okay. All right. We're going to try to turn to
Can I add one thing, Renee?
Oh, yeah, please go ahead. Yeah.
Sorry, I think the other factor, I mean, totally agree with Maddie on all of those cases. And I think ultimately, like they're going to be lengthy appeals. I think some of these design feature issues may ultimately go up to the US Supreme Court, given that there is disagreement still amongst circuits. But I think the other really interesting factor, or other two interesting factors, are the ways in which litigation catalyzes changes in public conversation. And so I think the reporting and coverage around these issues is extended well beyond my sort of tech policy bubble into like the rest of my life. And people are watching these and discussing these issues in more detailed ways, which in turn is increasing pressure on political figures. And so we've seen movement at state level, at federal level. We've seen op-eds writing about how Congress needs to act. How exactly that's going to play out in this political environment, I don't know. But I think it's entirely possible that these cases catalyze more congressional and state level action. We saw a hearing last week on the Hill, specifically bringing in the fact that this litigation is unfolding as a sort of incentive for more kind of policy-oriented legislative activity.
Yeah, I mean, I mean, I guess I have a bit of a question around like the attempts to kind of get in the way of that too, because of course, last year Trump tried to pass the preemption on state level AI law. I know that that's separate from the social media, particularly, but and then tried to do that again. The defense bill has now tried to do it through an executive order, and I think is on some level trying to bring that to Canada via trade agreements and to other countries as well. So, I mean, I guess as we're thinking about, maybe that applies more to a chatbot case than a social media case. But I guess my question is, just given the vast amount of resources that are going and pressure and coordination with companies, how do you think about how to address these attempts to prevent accountability from some of these harms?
Yeah, I think it's an interesting question. I mean, there's been some reporting that some have said that the sort of kid safety legislative package in the US Congress could be a vehicle to get AI preemption over the line. And there's been debates about the degree to which there should be carve-outs for child safety. I put in the chat a letter that was released yesterday from a range of attorney generals, I believe yesterday, yeah, specifically challenging the Kids Act, which is the sort of House version. And this letter includes, a bipartisan group of attorneys general suggesting that federal activity could actually impact some of the litigation that's unfolding. So I think it's a rapidly evolving sort of political landscape. And my own analysis, there are others on the call who could offer theirs as well, is that it's breaking down sort of politically and ideologically in interesting ways. Like there's not just like two coalitions or sort of like two sides of the political spectrum. You have folks for different incentives looking at pursuing legislation and litigation in ways that aren't just sort of partisan.
Great. Okay, so we have a couple questions in our Q&A. Some Harshini wrote, can we get access to any of the data regarding Meta's scam ad percentage and regarding the CSAM account? So I know that we have a report ourselves in our policy submissions called the scam tax. Maddie, I know that you mentioned that you also have a report on scams. And I know that Jeff Horowitz has had a lot of reporting on this topic. Maddie, do you want to talk a little bit about that?
Yeah, so it's rather than a report, actually, it's a lawsuit.
A
But
lawsuit.
if you look in the complaint, we actually mostly drew from public reporting that in turn came out of documents that came out of the social media litigation. So it's another example, I would say, of how while it's taken time, the US litigation has resulted in some kind of transparency around internal decisions that are being made. But I would definitely recommend actually looking at the complaint itself because there's a lot of good data in there, and we cite to the specific sources we pulled from that include the kind of internal documents that talk about the really shocking 10% of Meta's revenue coming from scam ads statistic.
Yeah, I've just dropped also the one of the articles, but Reuters has a wider series on Meta's secret of success, which I'm dropping here as well. So you can find some of the stats that Maddie is talking about there around the 10% of ad revenue, which was going to be around $15 billion in 2024 alone. And also, I think there's also some information there about the fact that their thresholds for taking down suspected scam ads was 95%, and that they would leave ads up that they suspected were fraudulent, but they would charge a surcharge. So there's quite a bit around that. So check out some of that. Okay, we have discoveries in these cases revealed how algorithms might promote foreign information manipulation.
I don't believe so. I mean, I think there is certainly discovery around the sort of ways in which the algorithms are optimized and sort of the values they're tuned towards. I think I have not seen in the context of the Meta and TikTok documents, which are the ones I've looked through in most detail, like that specific risk, which maybe makes sense given the nature of the consumer protection and products liability claims.
Yeah, I mean, I imagine that the same kind of incentives around engagement-based algorithms, sort of, really sort of stoking emotional content would probably lead to that, but perhaps these cases have not really brought those out. Although I know that there's been some reporting from IT a few years ago on that, so I just don't know if that's come out in the litigation. But okay, all right. Our next question here is. Has there been a significant verdict against Meta TikTok that has previously led to design feature changes? And I believe the answer to that is no, but Peter, do you want to kick us off?
In the US context, I think these recent cases are too early. I will say in the European context, for example, TikTok had proposed to roll out a feature called TikTok Lite, which was specifically targeting sort of younger kids, and they had to do a risk assessment in the DSA under the DSA, and in the end opted to not roll that feature out in Europe. So I do think that could be an example of like a concrete design change that emerged through a sort of regulatory approach. But I think these cases, really this public nuisance claim in New Mexico is going to be the first sort of significant bite at the injunctive relief apple when it comes to design change.
It's a fascinating approach that they're taking there. I'm really curious to see how that goes ahead.
I just
And
Okay,
I mean,
go ahead.
Sorry,
go
I
ahead.
just wanted to quickly add on the AI chatbot front. We
Mm.
haven't seen kind of binding remedies enforced by a court, but as was mentioned earlier, we are seeing kind of companies making voluntary changes that seem to be really heavily influenced by litigation they're facing, both from Character AI and also from OpenAI's ChatGPT.
Okay. Okay, we have another question here. What are the next steps to hold platforms accountable if Meta can estimate user age? What challenges exist for age verification tools, and do harms apply to adults as well? And so I think, yeah, Peter, I'll let you take that one.
Sure. I'll put in the chat a report that we issued in January, which was a technical assessment of different age assurance mechanisms. And I think broadly, I mean, this is obviously a very sort of pertinent political conversation in many parts of the world with the Australia social media delay or ban, conversations really taking off in Europe as well. And I think Meta certainly does estimate user age. What they communicate to their from an advertising perspective is about that segmentation specifically. I think well, there are a host of risks from my perspective associated with age verification tools. But I think one key learning that we're seeing from the litigation is that platforms and age assurance companies like they're going to have much more granular understanding of effectiveness. And right now, they're communicating in ways around, default safety features that don't get into any of the nuance or sort of technical understanding and trade-offs associated with different approaches. So I think a key lesson for me from this litigation is the specificity that's necessary to understand the degree to which safety tools and sort of interventions are working, how they're working, what the sort of trade-offs of those tools are. And so I'm fairly wary of a sort of simplistic age verification debate when we know there's actually a lot more nuance and trade-offs associated with it. And I think what we should be demanding is a far more rigorous understanding of the performance of these systems.
Okay, there's one more question here. Could these rulings really truly lead to safer online experiences? What's really the best case scenario here?
Yeah, I mean, I think it's an open question. We'll see. I think a lot depends on um, the strength of the remedies that are implemented in cases that are able to win kind of behavioral remedies in addition to monetary ones. I do think that the like scale of monetary liability does make a difference and could shift incentives in positive ways that would change company behavior just because of, the pure scale of the number of plaintiffs that have cases against these companies. But what we've seen in the past from big tobacco, for example, is that it's really important to have both the monetary remedies and also remedies that are behavioral that kind of specifically mandate changes to companies' behavior. And so that's why I think the work that KGI and TJL and the Neely Center are doing around developing frameworks for remedies at this particular moment where cases are kind of moving into that stage and considering what to potentially implement are so important because, you know, the stakes are significant. If good and effective remedies are implemented as part of this litigation, it could really make a significant difference to people's experiences online.
And maybe
Just yeah,
just to add to
please.
that very quickly, Renee, just like sort of regulation through litigation is kind of like American as apple pie, to use a bad expression. We've seen this approach in other sectors, and I think the effectiveness, as Maddie says, is ultimately going to be the degree to which there are those more sort of systemic settlements or interventions that, through legislation that sort of address to the harms that have come through litigation. But I think it's a very different approach than what Europe is pursuing.
Yeah.
But I think clearly with these two initial victories, it's a path that plaintiffs' firms and attorneys general are going to continue to invest in, given the initial success.
Okay, thanks so much. Just given our last couple of minutes, I mean, Canada is, in this phase of trying to get its online harm bill. I think presented, I believe, this spring, perhaps in the early fall. But if you are trying to share a couple of key recommendations that emerge from these trials and from the research that you're doing about top priorities that you would want to see, where would you focus in your case? Peter, why don't you start?
Great. Again, with the sort of waiver disclosure that I've not been following the specifics of the bill.
Sure.
I do think what this case or what these cases, as well as what's emerging through regulation in other parts of the world are showing, is really this focus on design is critical. In the US context, that's true for sort of the legal kind of structure or the legislative structure, but also around effectiveness. I think sort of targeting specific types of content or sort of content moderation debates are very hard to resolve. I think they're just different perspectives on content-based issues. People have different sort of engagement with those forms of content. Whereas looking at the actual design of the platform and some of those sort of more core infrastructure that then link out to other types of harms or to specific types of harms that cut across different user groups. And there was a question around minors as well as adults. I think it is important to underscore that many of these issues also affect adults. And so looking at a legislative framework, I think taking those lessons around design and how you can move sort of upstream to intervene is an important reflection.
Great. Maddie, any last thoughts on your side?
No, I completely agree with everything Peter said. And yeah, I think just to underscore, like in the remedy framework, we have these different categories of harm prevention, harm mitigation, and governance. And I think from a policy perspective, the harm prevention category of remedies are a really great place to look for interventions that can be made upstream that will prospectively reduce the kind of harms that users are experiencing across a whole range of different harms that are affected by algorithms that are optimized for engagement, from the kind of social media addiction and mental health harms to the sexual exploitation that we've seen in both these cases, but also I think some of the other harms that were raised in the questions that are more related to like how our current social media environment affects democracy and discourse. And so, yeah, I agree with Pete completely.
Great. And I think, Peter, you'd probably agree as well that just like thoughtful transparency obligations that are kind of rooted would be a pretty core piece as well, I would think, hey?
Yep.
Yeah. Okay, well, I think that's all for today. Thanks so much for everybody for participating. Our next session is going to be with Build-Up's Helena Pugh-Larari. We're going to be talking about polarization and what's the role of policymakers in trying to trying to regulate when polarization is monetizable. And we're also going to be having another session coming up in a little while on whistleblowers and whistleblower legislation. We are ourselves releasing our deception economy report in the coming weeks. So we'll be sharing that all out with everybody here, but also come and take a look at our website. And please check out also the Council on Technology and Social Cohesion, all the work that they're doing, Knight-Georgetown Institute, Tech Justice Law. Thank you both so much, very much for being here with us today. Bye.
Thank you.
Thanks so much.